All right, let's get started on 652 with R.P. Davis. Ms. Latrice Williams. Would you brief that one for us? Can everybody hear her?
When the physicians breached their contract with Davis breached its contract with Dallas and refused to accept delivery of medical equipment. Dallas sold the contract equipment to another purchaser for the same amount as the contract price. Davis and sued Dallas to recover $300,000 down payment, less $500 as provided by the Uniform Commercial Code, and they agreed upon. Davis was entitled to return the down payment on the bill, but asserted that it was entitled to a set-off for damages. Diagnostics incurred as a result of Davis' breach and claimed that it was entitled to damages for lost profit. The trial court found that Diagnostics' damage was limited to the difference between the contract price and the resale price as available under Section 2-7. And the holding of the court was yes, that where a seller would have been able to produce and sell another product as well as the product produced under the contract and would have been profitable to do so. That seller was considered to have lost sales volume when the buyer.
Is that it?
And the issue was where a lost volume seller needs to find a new purchaser for a product to allow of sales can sell the total for lost volume if it would have been low possible and possible to make that sales for another person.
Okay, so what happened on the case? Okay. Everybody got that? There's several things in this case that you need to notice. The first of which is this term called a set-off.
What?
A set-off. S-E-T-O-F-F. One word. What does a set-off sound like it is? Yeah, it's a credit against a judgment against you, isn't it? To set off a judgment is, you may have a judgment for the $300,000, but you're entitled to reduce that or to set it off by the amount of profit that you should have incurred, in this case from lost sales volume. So the set off is a term you need to be familiar with.
Can you give that definition again, please?
It's basically a credit against judgment against you. If you want a better definition, go get Black's Law Dictionary. I'm telling you the common sense. Set off is a credit. The next thing you need to notice out of this opinion is it went to the 7th Circuit Court of Appeals, but it was a question of state law, wasn't it? Did you notice how on 653, that first paragraph under Roman numeral 2, it says, "Thus we must attempt to predict how the Illinois Supreme Court would resolve this issue if it were presented to it." The reason that the 7th Circuit has to do that is because it's a federal court, and what it's looking for is state law precedent to determine what state law is in order to apply state law to this question. And because they are not the final authority on what state law is, who is the final authority on state law? the state, the highest court in the state. Some courts call it the Supreme Court, some call it the Courts of Appeals. In Alabama, we're not backwards. We call it the Supreme Court, just like the U.S. calls their final court the Supreme Court. But in places like New York, I think they call it the Court of Appeals is the final court. So to alleviate any confusion from that, we'll just say the state's highest court is the one who gets to decide what state law issues are. And they are the final word on what state law issues are. Who do you think's the final word on federal law issues? The U.S. Supreme Court. Now, in this example, they said since there's no state law answer on this, we're going to have to guess what the state court would have done in this case. Actually, they didn't have to do that. There's a procedure over in, well, it's a civil procedure, but a federal court has the right to submit a question to the state court. It's called a certified question, where the federal court can certify a question to the state court to say what is the definitive state law position on this issue, and the state's highest court can say this is what the law is and answer back to the federal court, and then the federal court can apply that answer to whatever facts are before it. The alternative to that is that they can guess what the state Supreme Court would have done, and that's what they did in this case. It probably would have been better for them to get a definitive answer from the court rather than to guess, but federal courts have the option to do either. Now, from a precedence standpoint, and whether or not you have a binding precedent, would you think that a state court issue determining a final issue is a final decision, or a federal court's guess at what the state court would have done would have been a final issue? The state court, because it's a state issue. What I'm trying to point out to you is the fact that even though a federal court guesses at what the state court would have done, that's not definitive. You can still argue that the state court still has the opportunity to decide that and is not bound to follow the federal court's guess as to what that would have been. So that's an important procedural thing to understand out of this case, as well as understanding what a set-off is. The set-off being a credit against whatever judgment it is that you're entitled to. Another example of when you might use a set-off is a landlord-tenant action where the tenant doesn't pay the rent. The tenant gets kicked out and the landlord sues for the rent, but the tenant may say, I'm entitled to a set-off because they kept all my personal property. You see how they would get a credit against the unpaid rent because they kept the personal property? So the set-off is kind of a flexible term, but you'll see it a lot in contracts where one contract says one thing and another contract says another, and to get a balance of those two actions together, you set off one judgment against the other. Notice also that the court, in guessing, and so I'm going to assume that this is because they picked the case and put it in the book, that this is going to be a general statement of the law on volume sales, is that in order to recover on volume sales, number one, you'd have to show that you have the capability of producing that many goods, and then number two, that you would actually have made the sale. And so on the very last part of the opinion, it says Diasonics, in addition, must show that it probably would have made the second sale absent the breach. That's the second prong of that test. The first is they had the capability of producing the extra material, and then they probably would have made the sale. Now, how much would they have gotten in this case had they not said lost sales volume? Y'all read the case, right?
Yes.
How much were they entitled to for the lost sale if it wasn't a volumes claim?
The profit, only the profit.
Just the
They sold it for the exact same price, so what's their lost profit? Zero, right? Well, it said that they were entitled to the $500 for the refund, but that was under the contract. That wasn't the damage calculation, because if it's whatever your sale price is minus whatever you ended up having to sell the items for, that was actually zero. So if you were the attorney in that case and they came to you and said, oh man, this guy backed out of the contract and didn't buy our widgets for $100, so we had to sell them to somebody else for $100. How much do you tell them their claim's worth? $0. It's not worth anything unless you have other means of recovery, such as the lost $500 liquidated damages in their contract, or you make an argument like loss of sales volume. Notice also on note number 2 on lost volume, on page 656, the outcome may turn on who has the burden of proof on the issue of lost volume. First sentence of the second paragraph. What that tells me is there's not a uniform practice as to whose burden of proof it is. I will tell you, generally in the law, if you raise an issue, you have to prove it. And in this case, they raised the issue of lost profit or lost sales volume. And in that case, guessing what the state court would have done, they required that if you raise an issue, you're going to have to prove it. You raise lost sales volume, you've got to prove that you have a lost sales volume. Now, the second general issue that you need to know as far as rules of law is if you fail to raise an issue, it's waived. So if you fail to raise it, it's waived, and if you do raise it, you have to prove it. That's 2 good general rules of law for everything you're going to learn in law school. All right, 657, losing contracts. The introduction to it points out 2 code sections in the UCC, 718 and 709 at the bottom of 657. And Ms. Westry, will you do U.S. versus Algernon Blair on 658?
So this case was a suit brought up by Coastal Steel under the Miller Act, and Coastal Steel sued based on recovery for quantum merit. So the facts in the case were Blair entered into a contract with the United States to construct a naval hospital, and the defendant then contracted with the plaintiff to perform steel erection and supply equipment. Coastal began its performance utilizing its own cranes for handling and placing steel, and the defendant refused to pay for the crane rental. Coastal therefore terminated its performance after completing approximately 28% of the subcontract. The defendant completed the job with another subcontractor, and Coastal sued to recover for labor and equipment furnished. The quantum merit recovery is not limited to an action against the quantum contractor. It can also be brought against based on the Miller Act. So the issue in this case was, can the plaintiff recover in quantum merit even though it would have lost money if it had completed performance? Yes, it can. Recovery in quantum merit is an equitable alternative to actual damages, and a property under breach has the option to forgo any suit on the contract and claim only the reasonable value of its performance. The plaintiff has the option of recovering damages for a breach of contract that would have resulted or in quantum merit for the value of the performance already completed. This case was remanded for computation of damages in quantum merit.
Everybody got that? So what happens if you breach before you finish the job? If there's a breach before you finish? All right, let's talk generally about breach of contract claims, okay? In order to prove a breach of contract, number one thing you have to prove is the contract. That's the first element for breach of contract. The second thing you have to prove for a breach of contract case is what? That you have completely performed your obligations under the contract. The third thing is that the defendant breached, usually by non-payment, And then the fourth element is, what are your damages? So let's go through this. Was there a contract in this case?
Yes.
Yes. Was there complete performance by the plaintiff? No. That's where the breach of contract case falls apart. And the first 100 pages that we read in this book, it tells you that when you don't have a complete contract, what are some of the remedies that you can bring? One of which is quantum meruit. And that is for the value of services that you've provided, right? I don't know how they came up with 28% as being the amount of completion that they had done. Maybe they count the number of steel beams and the number that was supposed to be installed versus the number that was installed, and they came up with 28%. So when they didn't pay for the cranes to actually lift and install the steel, is that a breach by the contractor?
Yes.
Yeah, John Blair didn't pay for it.
Yeah, apparently under this case it was, right? Now, what was their argument as to why the plaintiff should not recover anything in here? Because it was going to cost them more to complete the contract than they were due to be paid, right? That's what this losing contract was. You're going to lose money if you complete it. So what did they do? They said, it doesn't matter that they didn't complete it. The remedy for a partial performance on a contract is quantum meruit. And what are you entitled to on quantum meruit? The value of what you've provided, and not necessarily in reference to the contract price. So when you look at the notes, I guess on 660, starting on 659 and 660, they talk about a ceiling price under note number 2 on 660. So quantum meruit, you're entitled to the money that you would, the value of whatever it is that you've provided. And then they suggest on 660 that only up to whatever the contract price is, right? Well, if it's strictly quantum meruit, then you're not limited to the contract price because you're not suing for breach of contract. You're suing for the value of the services that you've provided. And so can you exceed the contract price on a quantum meruit claim?
Yes.
Yes, you can.
And is that because maybe perhaps you gave a discount in the contract and your true value of service is more than that? Like how
It's going to be whatever you can argue. If they stop you from being able to perform the contract, you're entitled to the fair value of what you paid. Now, if you look also on 660, the last paragraph of note number 2 says, well, what if you're 99% complete? That's not complete, is it?
No.
So are you entitled to quantum meruit or the contract price?
Quantum.
Well, that's where the law kind of picked up on engineering. 99% they said is close enough.
Why would that not be substantial?
Well, it was. It's close enough to complete to performance that they say you're going to be limited to the contract price at 99%. So something less than 99%, you can make the claim for quantum meruit. But if you're at 99.9 and you are stopped from finishing your work, you're going to be limited to whatever your contract price is. So they do apply those limitations in it. Now, for a practical part of this, quantum meruit, let's say a client comes to your office and says, I want to hire you to represent me in a car wreck case. And you do all sorts of work, getting their medical records, getting the police report, getting an expert to go out and find out what the true cause of the accident was. And you've spent this thousands of dollars getting this case ready, and your client comes in a year before your case is set for trial and says, you know, my brother-in-law just passed the bar. I want him to handle that case. You're fired. and you took the contract for a 1/3 contingency, and they come in and they fire you, have you completely performed your job to represent them in the car wreck case? You have not. Because most of the time it includes taking it to trial. If there's going to be a trial or whatever settlement on it. So now, are you...
Hourly rate at that point?
Huh?
You just bill out at an hourly rate at that point?
Well, the problem is your contract was for a 1/3 contingency. How do you bill them hourly? You've seen that no attorney fees if we don't recover for you. A lot of attorneys do that. And so they'll just write it up as, we'll take 1/3 of whatever it is that we recover for you, if we recover, and if we don't, then you don't owe us anything.
Well, could you essentially sell all of this work that you had done to his new attorney so that his new attorney now doesn't have to do all that work?
Well, here's the thing. The state bar takes the position that the client file belongs to the client. So everything that you've built up belongs to the client.
Oh, it goes with him?
When they fire you, they're entitled to pick up their property, which is their client file, and take it with them.
That's
So-
bad.
So how do you get out of that?
Charge.
Yeah, there's this thing called an attorney lien. 34-1-60, I think. No, 360. 34-3-60 or 61. In Alabama, they create this thing called an attorney lien that says you're entitled to assert a lien against your client's property until you've been compensated for your work. So how much is your work worth in this case? If they have, well, let's talk about breach of contract. They have fired you before you've been able to complete your work. Is that a breach?
Depends on what your contract says.
Well, it does depend on what your contract says, but
Well, they have a right to terminate their attorney.
yeah, we learned that lesson painfully last week, didn't we?
It's still a breach.
Even as corporate counsel, they have the right to fire you, and you have no remedy for wrongful discharge. So what do you do?
I'm saying they have the right, depending on the contract, they probably have the right to do it, but that doesn't mean they get to get off with nothing. They have to probably give you some type of.
And there's one example for you, but what if the contract's silent on that? As an example, a good attorney would probably say, I'll take this case for you on a 1/3 contingency. However, if this case is terminated by either side prior to the completion of this work, then you'll pay me at a rate of X number of dollars per hour. That would be in the contract. But absent that, if you just say no recovery or no attorney fees if I make no recovery for you and it's 1/3 contingency, and then you get fired because brother-in-law passed the bar exam, are you out your money? We heard attorney lien pop up. So yes, you
Fair
can.
market value for your work.
There you go. What is fair market value?
What it's going for.
It's called quantum merit. The value of the services that you've provided, you are entitled to sort of a lien. Now we have the lien, and you can hold on to their file until they pay that, and you can assert a quantum merit, saying I'm entitled to this much because here's how many hours and the expenses that I put in. And you can say, I'm holding your file until you pay that because that's the attorney lien. Does everybody follow that? That's going to be the most helpful for you if you get involved in one of these contracts. Take another example. I guess this came on Judge Judy yesterday. It's a good example. This woman hired a lawyer to represent her at a preliminary hearing on a criminal matter. She paid him $2,500 for a preliminary hearing. I think that's kind of high, unless it was a murder charge. But $2,500, he talked to one police officer and he wrote a letter. Is he entitled to his full $2,500? I would not think so either. Neither did Judge Judy. So what is he entitled to if the client fired him before he finished up the work? Quantum merit. What was the value of the services that he provided? So it's not just civil if you take the case on a contingency, but if you do a contract to represent a criminal on a criminal defendant on a criminal case, and you only say $2,500 for a preliminary hearing, then you're entitled still to quantum merit if you have not been allowed to complete your work. And
Mr. Bodie, is there different, like would, like a intellectual property attorney, would he bill out at a higher hour than somebody that litigates in civil court? I mean, just in a, like personal injury attorney?
I don't know what he would bill out at.
I mean, what I'm trying to say is quantum merit, is that, are there different hourly rates depending on what you specialize in?
It's going to
Fair market value wise.
fair market value wise, what they're going to consider for what is the value of the services you provided is going to be a reasonable hourly rate for the work that's been done. Now, can you introduce evidence that says, yeah, I charge at a higher hourly rate than others? Then you're probably going to have to justify that with knowledge, expertise, experience. This is why I am entitled to more. And the judge will make that decision, just like they do on quantum merit. What your hourly rate's going to be, they determine the reasonable amount of hours and the reasonable rate. Now, as far as what attorneys charge per hour, I know of one attorney that charges $1,000 an hour.
There's an intellectual property attorney in Huntsville, he's $800 an hour.
800. And then I know a lot of young attorneys that start fresh out of law school. They charge $100 an hour. That seems to be like a magic number everybody seems to pick. I don't know why. If you go through your business model and you take all of your fixed expenses and your variable expenses and come up with what amount you want to earn at the end of the year, and you figure out the number of hours that you can work and you divide that out, that's how much you're going to have to charge for your hourly rate in order for your business to actually make money and put food on your table. So coming up with a number out of the wild like $100 an hour, that's a bad idea because you may be selling yourself short. On 661, the cost of completion, if you don't actually go in and figure out what your expenses and including salary are going to be, and you don't divide that out by the number of hours that you're going to work, then you're going to potentially chronically underbill and you'll lose money. So what do you charge per hour? I don't know. It depends on what your expenses are going to be to set up your office and what you're going to take as a reasonable hourly rate. All right, cost of completion and diminished value on 661. It says the party seeking a remedy, they have to show that non-conforming performance justifies the remedy sought. That's called the substantial performance doctrine. You need to know about substantial performance. They introduced you to that with the 99% complete on the page previous. Do you think that's substantial performance?
I would think less.
Huh?
I would think less than 99%.
Is there a magic number? Like maybe like 50% is substantial?
It's not a magic number, it's a magic phrase. You know what that is? It depends. Not only the best answer in law school, but the best answer in the law. I'll give you another example. What if you get somebody locked up for non-payment of child support? Criminal contempt. They found that they didn't pay their child support on time 10 different times. So they give them 5 days in jail for each one, so that's 50 days of jail time. And they say they're going to serve this jail time if they don't comply with the court order. And the court order says you have to pay your child support every month on the first of the month. You come back 6 months later, and 5 of the months they made payments on the first, but because the first was on a Sunday, on one, they paid on the second. Now, have they complied with the court order?
Well, technically no, but the judge is going to say they gave you your money, so.
All right, let's rephrase that question. Are you going to put them in jail for 50 days for being late by 1 day because the 1 day was a Sunday? What are you going to call that? Substantial performance, right? That's the concept. Is it's not always a hard and fast rule. You have to take circumstances into consideration. Right there in Plant v. Jenkins in the middle of that paragraph, substantial performance as applied to construction of a house does not mean that every detail must be in strict compliance with the specifications and the plans. Something less than perfection is the test. No mathematical rule relating to the percentage of the price, cost of completion, or completeness can be laid down to determine substantial performance of a building contract. Well, if you take everywhere where it says building out and you substitute any other contract in there, is there a hard, fast rule on calculating actual performance versus substantial in any of those cases? No, so that's basically a good general rule of law. If you want to go ahead and highlight that sentence out of there, that's a good substantial performance skeleton for you to use. Just
Where were you reading that from?
661, the middle of the first paragraph under cost of completion, starts off with a quote, substantial, where the S is lowered cased. Everybody got that? All right, so let's talk about building houses. How many of you have had your house built by a contractor?
How many are in a lawsuit?
I hadn't asked that yet. All right, were there specifications that you do a walkthrough, right? And you see what it is that they've done and what needs to be fixed? Well, believe me, I went through and I nitpicked the crap out of stuff. Now, for the things that were big, they did go in and fix them. But for the little things like the quarter round molding down at the bottom where it didn't line up perfectly with the wall, I said, you need to fix that. And they didn't. Is that a breach of the contract?
No, because that's not.
If the specifications say that it has to lay flush with the wall, is that a breach of the contract?
Is strict compliance in the contract?
Well, you have to account for like settling, and they use all that, like the house settles. And,
Well, look at our definition. It says every detail must be in strict compliance. So did they technically breach the contract?
Yes.
Have they substantially complied? Or substantially performed the contract? So if you were to take that to court for one piece of quarter round that didn't lay flush up against the wall, do you think you're going to win your case? Because the other attorney, if they're smart, are going to come in and say substantial performance. The test really on construction contracts is a good and reasonable workmanship standard. Well, what is a good and reasonable workmanship standard?
What a reasonable person would think.
Mostly complies with whatever the specifications are. Mostly, not all of it, not strictly. And then look at the next paragraph. It often entails a choice between the difference in market value of the expected and received performance on the one hand and the cost of completing the remedy of the non-conforming performance on the other. That's your choice of remedies on these types of cases. And then they get into that with our next case, which is Jacob and Young's and Mr. Stokes.
Yeah, in this case, the Kents sued Jacob Young, their contract build case of build a house and to pay $77,000 for it. He wanted pipe from a certain place, Reading, Pennsylvania. Very important. They had a specific pipe throughout the whole house. Well, some of the parts of the house had used different pipes that weren't from Reading, and so he didn't pay the final payment to Jacob Young. He said that they had to switch out the pipes, but it wasn't easily accessible, so they had to do a lot of other work, and he wanted them to pay for it.
Not easily accessible, meaning they had to tear down walls.
Yeah, they had to do a lot more work. It was gonna basically rebuild a part of the house. It was going to cost a lot of money. And they wanted the construction company to pay for it. Took it to trial. The trial court said that it wasn't. They didn't have to pay the construction fees. They would just have to pay the difference between what would be the quality of the pipes would be different quality, and that that's what the trial proved, that the quality of the pipes was the same. If a party substantially performs the obligation of their contract, that party will not be forced to bear the replacement costs, need to fully comply with the agreement, but instead will owe the difference for the non-breaching party between the things that were valued between full performance and partial received.
Okay. Look at the general rule of law that's in the middle of 662. And it's in the middle of that big paragraph that starts off in the circumstances of this case. Look about halfway down through there, the sentence starts off with, "It is true that in most cases the cost of replacement is the measure of damages," or is the measure. "The owner is entitled to the money which will permit him to complete, unless the cost of completion is grossly and unfairly out of proportion to the good to be attained. When that is true, the measure is the difference in value." That's your rule of law out of this case. Now, y'all know what I mean when I say that's the rule of law out of this case? It's like if you see a question on your exam where the fact pattern looks like it's grossly disproportionate to pay for a repair, what's going to be the value of damages that you pick as your multiple choice correct answer? The difference in value, right? Now, is there a real difference in value between pipes that are from one manufacturer versus another? Yeah, it does depend, right? But assuming that they're both good standard pipes, and by the way, you know that buildings have to pass building inspections, right? So is a building inspector going to allow something to pass that's not up to code? Not supposed to. So technically, is there any difference in functional value between those pipes? Not a bit, right? Yes, ma'am.
Putting little details like that in the contract, if the person can technically decide that they're not going to follow that part and just get something that's close enough to it. But like, I don't understand the contract is it's not a definite. You breach your contract and you were negligent on your part because you should have checked with the subcontractor to make sure that he was following, in the same way that the contract wanted them to follow.
Okay, I have an answer for you. Let's say that you're a contractor and you've contracted to build something and you can build that thing for $10,000. Or you could build it not quite to specifications, but close enough for $7,500, which means you get to pocket the extra $2,500. Which are you going to pick? Ah, perfect. That's the right answer. Yeah, and the funny thing is, you know how our federal government does business when they're in business? Who do they award contracts to? The cheapest. So while you may have somebody that says, I can do this work for this much money, the contractor's going to go in and start looking for every shortcut they can take to make more profit. That's just the nature of business, right? Yes, ma'am.
Did the ruling on this case have anything to do with the omission of the pipes being used or the different pipes being used? Did that have anything to do with it?
Yes, it had something to do with it because he was suing because they didn't use specific pipes, but the manufacturer used other pipes.
And substantial performance had absolutely...
Substantial performance was he had plumbing. It didn't matter what pipes you have, it substantially performed because you've got working plumbing. Now, one of these cases, or in the notes I read somewhere, that somebody wanted lead plumbing for their water supply. Did y'all see that?
They try to get rid of their husband.
Oh,
Trying to get rid of the husband.
y'all gotta watch out for her. Trying to get rid of the husband. Anyway, the good general rule of law is on 662 where I pointed it out to you. At top of 663, the notion of substantial as opposed to strict performance and the law conditions in general. They're going to take that up in chapter 8. But they're introducing you to this. Now, the relevance of diminution in value, note number 2. Diminution in market price is useful in fixing a lower limit of recovery, since the value of the property owner is substantially no less than the net price which the owner could sell it. Y'all see? Y'all understand that concept? That's important to point out. I want to make sure everybody understands that.
Can you say it again?
So the market goes down.
What is the least amount of damage that you can give somebody if they turn around and sell the property anyway?
Fair market value?
The difference in the market value. And if the sales price for the property as a whole is going to be one price, then whatever your value is, down to whatever they could sell it for anyway, that's the lower limit of how much value that they've lost on their property. Which a lot of times is not a whole lot, is it? Worst comes to worst, sell your property and cut your losses. Well, whatever you sell your property for as a fair market value, whatever a willing buyer is going to pay a willing seller, you can at least get that much money out of it, right? So that's why it says it's a lower limit, because you can always get at least that much money back out of your property. Now,
Is that sometimes murky because property is unique, like land?
sometimes. But at least with this, it's that particular value of property that you're looking at. What's its market value now versus what's the sales price. So because it's the same two pieces of property being considered, it's a wash. Doesn't matter that it's unique. It's what's the property worth, period, versus what's the diminution in value to that property. The next part about it is, similarly, the cost to remedy a defect is useful in fixing an upper limit for the recovery. Even if that cost is less than the value to the owner, the lesser sum will enable the owner to complete and avoid any loss in value. So what they've done is they've established an upper bound as well. You've got a lower bound for your damages, and you've got an upper bound. Everybody see that?
So, you build a house, contractor puts a regular 3-tab roof on it, you should put an architectural roof on it. The difference is, say, $3,000. The appraised value was $300,000, but you sold it for $298,000. It's $2,000 difference. You'd be limited to 2. Was that with the diminished value? Or
the maximum of 3 because that's the difference in value. Right. So it gives you a range. Yes, ma'am. I think she's just yawning.
I'm sorry, I was just yawning.
Proving diminution of value, note number 3. What that points out is the fact that if it's not just a property that you're going to hold for construction, and it's the house of your dreams, and you've built it on the only real property that's available for your dream property, then that's going to be more difficult to prove. The diminution of value is what value you put on the property rather than a commercial value. On 664, the last sentence in that says the appropriate vehicle for challenging such an opinion is cross-examination. Let's say you get a disgruntled homeowner on the witness stand and they say, this is my dream home. I always wanted my house to be like this. Very specific details. And because my house is not like that, I've suffered just a terrible personal atrocity. I've got personal suffering, emotional psychological abuse because the contractor didn't build my property the way I wanted it. And therefore I'm suing them for $10 million. And they get through testifying to that. And now you're the attorney that gets to ask them questions on cross-examination. What do you ask them? What do you ask somebody that's just gone absolutely nuts, overblowing the value of their case? Oh, folks, let me tell you what. You're going to have people that walk into your office and say, this is $1 million car wreck. You don't believe me? Just wait. First year of your practice, you're going to get people that walk in and think this is $1 million case. You're going to get them $1 million. Never mind subtracting your attorney fee out of it. You're going to get them $1 million.
They're so straight.
Are they delusional?
Yeah.
Okay, now you've got a delusional person on here.
Just ask them if they have any mental health issues. Have they been diagnosed with it?
That's a good start, probably.
Yeah, just trying to make them seem loopy.
Make them seem loopy?
Yes, that's the
Hey, look, my wife and I went to Walmart the other day to get some stuff, and this guy was in front of us in line, and he started talking about crazy stuff. He called my wife Roseanne, called me Tom Arnold. Then he said he was both a Muslim and a Christian and something else at the same time. Not sure how you do that. So he's just as delusional, and you run across these people all the time. $10 million because of their dream home not being what it is. What is the basis of your opinion as to the value of this property? It's my feelings, Judge. Well, the judge can't use feelings, right? How about, there was a note that I wanted to ask you specifically about the tearing down the wall, that case we had, the case before last, or this one. Let's say that we want to build a government building here in the state of Alabama, and we want to use marble from the state of Alabama down from Silicaga, I think. Isn't that where there's lots of marble?
Quarry.
Yeah, quarry. And then you find out that the builder shipped some in from out of state and used some of that marble from out of state to build an Alabama government building, who was going to boast the fact that all the marbles from the state of Alabama. Do you make them tear down the marble that they installed that was not Alabama marble to put Alabama marble in there? I see a head nod here, yes.
No.
Maybe it would depend on how much, maybe only
Nah, we're going to put this in state court.
Unless it was directly specified in the contract.
It was directly specified Alabama marble, but they shipped some in from South Georgia, okay?
Yeah.
They snuck some in because they were running short.
Was it a shortage on Alabama marble?
No, they just didn't keep up with the supply. There's plenty of marble.
Yeah. David Bryant to make them place.
So the diminished value of the project, maybe tell them the amount it costs to replace it?
Yeah, we've got diminished value argument up here. What else? Go ahead.
I was going to say, because the value was the fact that it's boasted it's Alabama marble, and they can't do that.
right.
Let me tell you what. Y'all ever been to the Supreme Court building down in Montgomery? Anybody?
Yeah.
Do you know what it's built out of? Alabama marble. So is this a real life fact pattern? Absolutely. The Alabama State Bar, Alabama marble.
But who would know that? I mean,
They're going to say
the person who would know and wouldn't care. So you can still boast it as Alabama marble.
that one person who finds out
A lot of people care.
Now, we hadn't gotten to fraud in contracts yet. But could you ask that they tear it down and replace it with actual Alabama marble?
Yes.
Now, is that directly contrary to this case that we just had in book? Now, is the court in Alabama going to make them tear it down and use Alabama marble?
Yes.
If Briar's involved.
What's the difference in value to the building that cannot be boasted to be made out of Alabama marble?
Might not be any difference.
Cost of
I mean, that's like specific to the buyer, like,
Yeah.
I mean, so the price is not set, there's no.
It's a big deal.
I think it makes a difference, and I would argue to tear it down and put Alabama marble in, just like you were supposed to.
In Alabama.
Because it's not a fair market value for a reasonable piece that I'm holding just for investment purposes. I'm actually building this as a landmark, an appreciation and a showpiece of the natural resources of the state of Alabama. Now have I convinced you, because it's a showpiece of the resources of the state of Alabama, that it needs to be Alabama marble?
Yeah.
I still got some no's.
Absolutely.
No. The taxpayers, hold on, let's straighten this out. The taxpayers agreed to a certain price to build it. It's the contractor, because Ms. Savage said, why would they do something cheap? Why would they do something one way when the contract says another? Because it was cheaper. So they cut corners for the same price to the Alabama taxpayers as if it had been built the way it was supposed to. So it's not going to cost taxpayers anymore. Do you make the contractor tear down those walls and replace them with Alabama marble?
Yes.
No matter what the cost?
It's not a cost to the state.
It's not a cost to the state, right? But it's what they agreed to build it for.
That's right.
And that if you put in there that this is going to be a showpiece of Alabama resources in your contract, y'all see where I'm going with this?
Sure.
What's the next section we study in here? Foreseeability. If it's foreseeable that you want specifically to have this and you'll have damages because you don't have this, is it the foreseeable type of damages the contractor should know about?
Yes.
Now you see how we're tying all this together. Okay, Plant versus Jacobs. This one's about unreasonable economic waste. Mr. Sorensen.
Yes. Plant versus Jacobs is out of the Supreme Court of Wisconsin. Plant was the appellee. He was a builder who contracted with Frank and Carol Jacobs to build a home on their lot for $26,000. During the course of the work, Plant was paid $20,000. There were disputes between the two, and Plant ceased to work on the home. And then he established a lien on the property in order to recover for the rest of the unpaid balance of the contract, plus additional expenses. Jacobs appealed upon the grounds of faulty workmanship and incomplete construction. The issue is whether the cost of repair or replacement rule in regard to substantial performance of work that is or was not completely performed be applied to several items in question. And always used to render the cost of damages due to faults in construction or a type of service repair work. I say no because the rule to apply the cost of repair rule in overall instances of faulty construction concerning several items or services defective. It's not an accurate and concrete rule to evaluate and assess damages because it can and it would negate items of only insignificant proportion. In the case, the main concern, it was the living room wall, which was a substantial piece of the house, and it would constitute a major cost to replace. The use of this rule, it would not adhere to the said defect, which the court deemed to not be legally bound for incomplete work or defection. So if it were found to be the diminished value rule, it would be a better application for the matter. Going back to it, the rule I found in use here was for damages due to faulty construction work. It amounted to such incomplete performance. It's what the difference would be between the value of the house as it stood with faulty and incomplete construction and the value of the house as it stands with faulty and incomplete construction. If it had been constructed in strict accordance with the plans and specs, it would be called the diminished value rule. And the court they ended up affirming the ruling for the plaintiff on the grounds of the, let's see, damages due to faulty construction.
They found for the plaintiff?
Affirmed the ruling for them.
That's right. The plaintiffs were the builders and the defendants didn't pay, right?
Oh, that's right, who the hell they excuse me.
Yeah, the plaintiffs were the builders that didn't get paid, and the defendants were the owners of the house. The owners were saying, we don't have to finish paying you because of this, so the builder brought suit against the owners. Look at the top of 666. The trial court properly found that the defendant suffered no legal damages. In this case, by missing the placement of the wall by a foot or a foot and a half on the inside of the house, just a foot or a foot and a half off to where it should have been, and allowing them to go ahead and build it and complete the work, how much would it have cost to tear down that wall and build it in the proper place? They called that economic waste. And in this case, they found that it was unreasonable and unjustified to require them to do that. Now, how could we have avoided that to start with? How about at the time that they had framed all the walls, have the builder come in and say, this is exactly where I want my walls, and then sign off on it at that point, and then they finish building it out? Can they have said to waive any arguments that they have against it if they signed off on the placement? Now, does it make a difference where the wall is?
It's a bearing wall.
If it's a load-bearing wall. Now, let's hypotheticals about load-bearing walls. If you're a foot and a half off on a load-bearing wall, what does that do with all the weight above that wall? It's going to change your center of gravity on the wall, right?
Right.
So what if you went in and proved that because it was a load-bearing wall and you changed the center of gravity, that the house is more likely to collapse in the middle because of the faulty construction? That would be different, wouldn't it?
Yeah.
Could you make that argument in court because of the load-bearing nature of the wall?
Yes.
Now, what if it's strictly just an aesthetic?
It's not justifiable.
Then it's not justifiable, right? How could the case have come out different? If you represented the builder. Now, if you represented the homeowner, if you brought an expert in that said it changed the load bearing and the center of gravity, and now I've got a 85% more chance that the inside will collapse in on that wall, would that make a huge difference to the judge or the jury?
Yes.
And in reality, what would the owner of that house do? Sell it and go somewhere else, right? Now you know why there's that bottom amount for whatever the sales value is. There are other terms called, well, look at 666, section 364 of the restatement. Don't miss that. Now I want to introduce you to another term. It's another kind of waste. It's called ameliorative waste. ameliorative, ameliorative waste. You know what kind of waste that is? That's the kind of waste that actually improves the value of property. So what if the builder went in and said, yeah, technically we didn't follow it, but now the property is worth more than it would have been? Not even an offset, right? Or a set off? If it's worth more now, can the builder come back and say, well, we need more compensation because we made it worth more?
Yeah, it's not the contract.
No, there's no chance of that. All right, roads. Mr. Smith?
The plaintiff owned a 24-acre piece of land. The land had a gravel processing plant on it, and he leased the land along with the plant to the defendant, who currently operated the same type of plant. The contract was for the defendant to process the gravel on the property, and what he was doing, he would leave the grade of the land below that of what the roadway was. Take all the excess dirt and everything and dump it somewhere else. When he finished processing the gravel, he didn't clear the land like he was supposed to. He left it a mess with all the extra dirt and everything on it. If he would have cleared it like he was supposed to and graded it, the value of the land would have been just over $12,000. But the cost to do that would have been $60,000. Judgment was entered for the plaintiff in the amount of $15,000, which was calculated with $12,000 plus interest. And he appealed, asking for the amount that would have cost to fully perform the contract. And the issue was how to calculate damages. Should they be calculated as the cost of completing performance? And yes, they should have been.
And what was the main reason they said it should have been the cost of performance in this case? It should have been the $60,000 instead of the $12,000, right?
Right.
Why did the court decide that? Because the breach was willful. One of the things you need to notice about equitable remedies is that in order to seek equity, you must do equity. And to seek equity, you must enter equity with clean hands. Is the willful breach or willful bad faith of a contract entitle you to equitable remedies? It does not. So you don't get the option of just the diminished value of property. You have to actually pay to finish it because you willfully breached the contract. They cover willfulness on 671, note number 2. Their breach was willful and in bad faith. That's kind of their assessment of the case. All right, PV House versus Garland. Mr. Siegel. Where are you, Mr. Siegel? Go ahead.
He said he's not ready.
Oh,
Sorry.
okay, Ms. Savage.
The plaintiff entered into a contract with the defendant so that it was a 5-year contract so that the defendant could mine for coal on the farm. To take immediate lien on the property. But I think the contract did not perform what they agreed to, fixed around the farm. And so the plaintiff sued, and on the trial level, they were awarded $5,000, even though they ended up suing for $25,000, they were awarded $5,000. Both parties appealed, and I forgot the part of the cost of the work for the company to do the remedial things on the farm would have been $29,000. So both of the parties appealed to the higher court, and they ruled that the plaintiffs were entitled to the excuse me, I'm probably going to mispronounce it, diminution value, which was $300. So they were awarded $300.
Now, in this case, they only got the 300 because it wasn't a willful breach, right?
No, I thought it was willful. Because they didn't want to do it because it would cost them $29,000, which again, going back to the case of the pipe, what is the point of putting this stuff in a contract? I'm sorry, I didn't agree with how these cases were written. Because what is the point of putting these things in a contract and these people can breach? You breach and you don't do $29,000 worth of work for these people after they let you own the time on their farm for 5 years. And then at the end of the day, all you can do is give them $300 because that was the value of the property that if they had done the work. But if these people really wanted that work done because the consideration on their part is letting you on their land for 5 years, then they don't have the $29,000 to go do the work themselves. So again, what is the point? Putting this stuff in a contract, if they can just do what they want to do and either get a slap on the wrist or get absolutely no consequences.
Okay, let's start off by what was the real purpose of the strip mining contract to start with, okay? What's the main purpose of the strip mining contract? The owner of the property owns land that has what? Coal. And so what are they trying to do with the coal? They're trying to sell it to somebody, right? So is the only thing that they get out of this contract just the fact that their land looks pretty now at the end of it? No, they got a whole bunch of money for the coal that they took off the property, right? Now, is the landscaping of the property at the end of the strip mining, is that an essential term of the contract to strip mine? It's not essential, is it? It's just remedial. It's the cleanup afterwards. And so I think the difference on that comes from the fact that it's not the main purpose of the contract, which was the sale of the coal. It's only the cleanup afterwards, and the fact that they literally did perform in good faith, taking all the coal they could get. But the cleanup's the one that they didn't do in good faith. And they decided that that was, I guess, economic waste in order to require them to do that. Mr. Davis?
I just want to make sure I'm squared away. This is what I took away from it. They think coal, strip mining company thinks they can get 100 cubic yards out of a piece of land of coal, but they end up getting 5,000 cubic yards. Obviously, it's going to cost a lot more to fix that. These people that own the land made a whole lot more money.
Oh, yeah. And so they're now suing. If they made millions of dollars off the sale of the coal, now they're suing for $5,000?
Professor Bodie, would it make a difference in a case like this where on a farm this occurred? If this were actually around where the family lived, would the restoration be more important to the contract than if maybe it were off on a more remote corner? I mean, would the court look at that aspect of where it was on the property?
That's an argument that can be made. Remember back to our road construction contract where they buried the debris and they were supposed to cover it up with dirt? They actually made them go and cover it up with dirt, right? The specific performance. What you're going to find on these cases, the right answer is it depends. It depends on what the attorneys argue to the court as to what kind of remedy the court's going to give them. And you're right, I don't think it's fair for them to leave a place. If y'all have seen what strip mining looks like, it looks like a war zone. And in this case, back in 1963, when they didn't really have as much concern about the environment or erosion, it would have been economic waste. But what if now with federal legislation passed that says you can't erode, that you got to keep clean air and water, because that is a law that passed since then, and that strip mining has a tendency to pollute the water, do you think the outcome would have been different because of now some federal policies that have been in place? I think it probably would have been. But back then, nope, they just only gave them $300, the difference in value of the land. Now, if the land were actually on the street, located on the street, or where you'd have to see it from your house, would it be different from an aesthetic argument? The answer is yes. but would the court see it as being valued different? Depends on what they argue to the judge. Look on the top of 672. There's another procedural thing in here. Things I wanted to point out on 672. Look at where it says at the very top, it appears the case was decided by a plurality rather than a majority of the members of the court. Now this is what the attorneys argued, okay? The attorneys picked a case that was decided by a plurality rather than a majority. Had they done their research and gone and found a case that had been decided by the majority, would the outcome have been different? The answer is probably so. Do y'all know the difference between a plurality decision and a majority decision?
Correct. They're not all there, right? They're all the judges and
No, all the judges may have participated. Here's the difference. A majority opinion is X number of judges decide this is what the outcome is supposed to be, and this is the reason that the outcome needs to be this way. Now, plurality, if you have a majority, say, of 5 justices, 3 of them may have said this is the right outcome for this reason, and the other 2 may have said this is the outcome for a different reason. You've got the right outcome as being a group of 5 judges, so you have the majority in that respect, but you have 2 different reasons. And neither of those reasons constitutes a majority of the court. That's what you call a plurality opinion. So you've got, basically it's non-binding authority, because you don't have a clear majority of the court saying this is the reason why we reached this outcome. You have the outcome itself is a majority, but not the reason. And the rationale of a decision is just as important as how many people reached it. That's what makes binding precedent. So that's the first thing to notice out of here, is that the attorneys did a shoddy job going in and finding their legal research because they found a plurality rather than a majority opinion. The second thing to notice is that Section 346 is outlined in here on your restatement about unreasonable economic waste. And then it says that the diminution in value is caused by the breach is the proper measure if construction and completion in accordance with the contract would involve unreasonable economic waste. So there's your distinction. The question is whether or not it's reasonable waste or unreasonable waste. If it's reasonable, the court will probably make you do it. If it's unreasonable, they'll let you out of it. And the last thing that they argued in this case that you need to notice is the next to last paragraph, relative economic benefit. That's part of their rationale, is that even though they could have been required to spend this much more money, the owner would not have experienced that much more increase in value. So you compare the benefit on both sides, and if it's not at least as much for one as it is for the other, you could argue that that's unreasonable. Limitations on damages on 674. They've come up with 3 types of mitigation in that first paragraph. I have that paragraph right after Section 3, almost the entire thing highlighted, because it points out your 3 limitations. No, the intro paragraph under Section 3, all the 3 different types of mitigation, that whole thing I've got highlighted in the book on page 674. And then mitigation is the first of the types that we talk about, and that's the avoidability, whether you can avoid those unnecessary expenses. It starts off with restatement section 350. Last sentence, under an important limitation on expectation, agreed promisee is not allowed to recover loss that could reasonably have been avoided. Section 350. Although the term is often used, there is in fact no duty to mitigate. So you do not have a duty to mitigate. That's another important thing. It's just that the injured party is simply precluded from recovering the loss that it could reasonably have avoided. That's the other part of this. So the promisor must compensate the injured party for costs associated with reasonable mitigation, including attempts, whether or not the mitigation occurs. So if you attempt to avoid losses, you can be compensated for your attempts, even though they're unsuccessful. And then where there's a market for goods, a buyer's damages are based on the assumption that the buyer could reasonably have avoided greater loss by obtaining substitute goods on the market. That's UCC 2-713. Ms. Reed, Rockingham.
Rockingham County, it was in the United States Court of Appeals, 4th Circuit, in 1929. The county commission, which is the defendant, contracted with Ruth and the plaintiff to build a bridge several weeks after Ruth started the bridge. The county decided to stop building it due to public objections. At this point, Ruth had spent $1,900 on construction costs. Even though the county told Wooten to stop, they continued building the bridge as per the contract. Wooten then turned around and sued for the total cost of building the bridge. So the procedural history, the trial court found in favor of Wooten. The issue is whether the plaintiff has to stop working and mitigate his damages when the defendant breaches a contract, or if he has the right to continue working as if the breach never occurred. This court reversed the trial court's decision, and their rationale is that county did not have a right to rescind the contract, and the notice given to the plaintiff amounted to a breach on his part. But after the plaintiff had received notice of the breach, it was its duty to do nothing to increase the damages flowing therefrom. The plaintiff does not have a right to proceed with the building and thus call up damages. His remedy is to treat the contract as broken when he receives the notice and sue for the recovery of such damages as he may have sustained from the breach, including any profit he would have realized upon performance.
Okay, everybody got that? So how much is the contractor entitled to recover? Okay, well, let's talk about quantum merit. He's entitled to recover for the value of what he's provided? Up to that point. So what's the value of what he's provided at this point?
Yeah, said he had spent $1,900 on construction costs up to the point that they told him to put.
Not how much has he spent. What is the value he's provided at that point? Huh? Oh, you can guess what the value is from the facts given in the case. What's the value of a bridge in the middle of nowhere that doesn't do anything?
$1,900 because there's no road.
It's not even worth $1,900, is it?
That's just what he spent, that's right.
That's what he spent. So what do you think he would be entitled to recover if he's outlaid $19,000, wasn't it? $900?
And then 20.
He's spent $1,900, but he's not finished the work. How much is he entitled to recover for a breach by the county? There you go. What he's expended plus any profits he was anticipating to make under the contract. So does he get the $1,900 back? Yes. Does he also get what his expected profit was under the contract? Yes. Now, take those two numbers and add them together, and that's what he's due to recover under the contract. Now, do you get a set-off for all the rest of the money that he spent finishing the bridge?
He should, they should.
That's what the court points out is, if you're going to work after you've been told not to, that's your dummy move. If you're going to keep doing something after you've been told not to, you're not supposed to, we're not going to pay you for it. That's what you need to get out of that case. An absolute repudiation or refusal to perform by one party to a contract, the other party cannot Continue to perform and recover damages based on full performance. That's right there on 676, second full paragraph. There is a line of cases running back to 1845. You cannot recover. That's what the rule of law is out of this. They also reference in the note UCC 2-704. Don't miss that on your outline, as well as restatement in section 45 on top of 677. Now, mitigation and contracts on the sale of goods. There's several code sections in the UCC: 706, 712, 708, 713, 23, and 24, all in there. You don't need those read to you. 703 and 711 is on the next pages. Next page. Ms. Myers, Tongish versus Thompson.
Okay, Tongish is a farmer, and he contracted with Decatur Co-op to sell the sunflower seeds off of 116.8 acres at a price of $13 per hundredweight for the large seeds and $8 per hundredweight for the smaller seeds. The delivery was going to be made in thirds, one delivery in December, one in March, one in May. The co-op was then to deliver the seed to Bambino Bean and Seed Company for the same price that it paid the farmer, plus handling charge of 55 cents per hundredweight. And that was the co-op's only profit that they anticipated to make on that exchange. So there's a poor crop, market prices go up. The farmer is under a contract and he's delivered the first delivery, but with higher prices available, he notifies them he's not going to deliver the next two deliveries on the seed. He's not going to perform the remainder of the contract. So he sold the balance of his crop to Danny Thomas for $20 a hundredweight, which was in total $5,153 more than he was going to make on the co-op contract. The co-op then sued the farmer. They recovered $455 in damages based on their loss of handling charges. The co-op appealed. The decision was reversed for determination of damages based on market price as opposed to just the handling charges. Tongish appealed, arguing the first decision was correct. The Supreme Court calculated the damages under, I assume that was a state statute. It said KSA 842713. They noted that this encouraged the honoring of contracts and market stability, and they affirmed the Court of Appeal order.
All right, let me point out to you on 679 KSA 842-713. That's Kansas statutes annotated. Chapter 84, or Title 84, Chapter 2, Section 703. Y'all got that?
Where are you?
At the top of 679. Now, notice also a little bit further down in that third full paragraph, the court indicated that Section 2-713 may be more of a statutory liquidated damages clause. You notice that says 2-713 rather than 84-2-713. You want to know what Kansas did on their statutes? Title 84 is the UCC. Chapter 2 is Chapter 2 of the UCC. 713 is Section 713. Almost every state does it like that. Just happens that Kansas picked Title 84 to throw it under. Alabama uses Title 6 or no, 8 maybe. So they've adopted the UCC and just placed it under a particular title rather than, so all the code sections line up with the UCC is what I'm trying to point out. Yes, ma'am?
Why would this case, I was thinking about this when I read it, but why would this not just be considered like an efficient breach where they're able to breach, but then just only have to deal with what the prosecutor did or something like that? So that's what it seems like. It's not necessarily bad faith, it's just a business decision for this.
Right, it was a business decision, but what do you have to pay when you make such a business decision?
You would, I mean, you would like lost profits or whatever it would have been for the other party. But that's not what they were awarded here. They were awarded more so to teach them a lesson, basically, so that other companies won't breach. But that's what that is for, right? And that's the whole point of having that efficient breach.
All right, well, here's the problem with it, okay? What happens after the co-op wins their case, and now the buyer of the seed from the co-op turns around and sues the co-op for the cover, having to buy other seed to replace the seed that they would have gotten under their contract?
I would say they would probably have a case against the original too, but
Now, they don't have a case against the original because there's no contract with it. So when the co-op sued the farmer to recover the money, they said the proper measure of damages was the difference in market value. Because what if the buyer from the co-op sues the co-op? They're also entitled to the difference in market value. So what does that leave the co-op with? The $55 per hundredweight. That's all they get left with. So you've got stacked contracts that if you only provide the lost profits to one, then the next one who comes in who has a contract that's dependent on that first one doesn't have the ability to recover their full remedy. Does everybody see that? And the court went back and said, yeah, it's not just the lost profits. The law is this. They didn't put it in the opinion that the stacked contracts is why, but you know that if the buyer turned around and sued the co-op, what's their damages going to be? Ultimately, it's going to leave the co-op with just the 55 per hundredweight after they pay off. Now, if they had been joined in with the lawsuit, say as a third party, let's say the buyer sued the co-op first, and then the co-op, in response to that lawsuit, turns around and adds in the farmer, then he would be entitled to that set-off for whatever the farmer owes him to what he owes the buyer. That would leave him with the net of the 55 per hundredweight. They kind of missed explaining the big picture on that one, but when you look at the fact pattern, it spells out everything you need to fix it, even though they only address the one part because that's the only thing currently before the court. All right, and they do point out the efficient breach over on 681. The problem with efficient breach is that you still have to pay the damages you cause. All right, Parker versus 20th Century Fox. There's a term at the top of 683 that you need to think about as you go through this case. It's called the Doctrine of Constructive Service. And Ms. Morris, would you do Parker? One thing before you get started on it, do y'all know who Parker is? Yeah, they never tell you that until you get to the note, right? So Parker is actually Shirley McLean. All right, go ahead.
Clay was hired on by the defendant to work as an actress in a musical film titled Blue and and the total compensation for the role was amounted to $750,000. The film was filmed on May 23rd, 1966. However, prior to May 1966, the defendant decided against producing the picture and sent a note to the plaintiff explaining this. In the note, it stated that the defendant would not comply with our obligations under the written contract. And in that same letter, it stated that another role was being offered to the plaintiff in a Western film titled Big Country. The only similarity to the two roles is the amount of payment the plaintiff was entitled to. The differences was the fact that one was a musical film requiring the use of her dancing talent as well as her acting abilities. And it was also to be shot in Los Angeles. The other one was to be shot in Australia. And then the plaintiff commenced an action seeking recovery of the agreed guaranteed compensation in the initial contract. The defendant tried to argue that the plaintiff's deliberate failure to mitigate the damages by not signing the new contract in the Western Film was unreasonable, and therefore she should not be compensated due to refusing the role. But the plaintiff moved for summary judgment under the Code of Civil Procedure, Section 437C. The motion was granted and summary judgment for $750,000 plus interest was entered in plaintiff's favor. That's when the defendant appealed, and then the Court of Appeals stated that plaintiff was excused from attempting to mitigate damages.
Why was she excused?
I'm thinking she's excused because she actually, it had nothing to do with, the roles, which was so different in the fact that, one required her acting and her dance, and then the other, and one was in Los Angeles and one was in Australia.
Okay, and the majority found that that was an inferior job, right? She wasn't required to mitigate to take something which was inferior. And they premised inferiority based on what their perceived notion of acting versus acting and dancing, and Los Angeles versus Australia. Now, how many people would like to actually go to Australia? Yeah, me too. How many of you have been to Los Angeles? Would you rather have gone to Australia? Why they think Australia is not a good place, I have no idea. And then acting, a film's a film, right?
But she didn't get to choose the director, and she didn't get to, there was other things she couldn't do.
But she also didn't get any control over the script either, did she?
Right.
And she had some artistic control over the script in one, and no control over the other. Yeah, it was a 1970 case. There's a term in here you need to know. It's at the bottom of 683. It's called anticipatorily repudiated. And sometimes you'll just see something called anticipatory repudiation. Now, you saw another term similar to that, just the county repudiated their bridge contract. Y'all, did anybody ask what repudiation was? Hey, we got somebody that looked it up.
It's, okay, let me see if I can remember. It's when
It's when one party comes in and says, we don't have a contract, I'm not going to perform.
Yes.
Actions or statements that does what? Disavows a contract? They say that they're not going to. Well, repudiation, when the work has started, is called repudiation. Anticipatory repudiation is before the work has started, they said they're not going to perform. So there's the difference you need to know between the two. Repudiation is actually when it's commenced. Anticipatory is before it's even started. Both of which are breaches. If you look at the opinion versus the dissenting opinion, the majority versus the dissenting opinion really gets onto the majority opinion by saying you've created these differences to justify what you want as your outcome. That might be true. But the problem is they got a majority of judges to agree that it was a inferior job, so she didn't have a duty to mitigate. On the top of 684, that first paragraph, the general rule, I got that whole paragraph highlighted as being good law.
Where is that again?
684, the first paragraph that starts off with the general rule, that entire paragraph is a good statement of what the law is that you need to get out of this. All right, note number 2 on 686, honor and respect. Personal service contracts often involve consideration not common in the other kinds of contracts. Personal service contracts often involve considerations not common in cases of other kinds of contracts. 686, note number 2, honor and respect. All right, how many in here are actual Tom Cruise fans? Got a couple of you. You heard they're going to make it Top Gun 2, right? Now, what would you say, instead of having Tom Cruise on it, if they had, what's that crazy guy? Pauly Shore. What if they cast Pauly Shore in instead of Tom Cruise?
Yeah.
Would you go and see Top Gun 2 if Pauly Shore was the... Why not? He's inferior? I've heard that. It's not the right vibe.
You can take it seriously. Yeah, you can take them seriously.
Okay.
Just keep reflecting on time.
That's why you cast particular people for particular roles. It's not something, it's just the overall feel of the person. It's called typecasting if you've never heard of it. You pick a particular person because they fit the type or the mold of the image that you want for that particular contract. And that's kind of what personal service contracts mean, is that you just can't pick out any actor and throw them in a role. There are other considerations such as the vibe, or the feel, or the seriousness of how you can actually interpret the actor. All of those things come into consideration when you pick a specific person to do a specific job. Now, can you measure what those considerations are and put them in a contract? No, you can't. You don't have the right vibe, Polly. I can't use you. Hey, that's a good term. You don't have the right vibe. Might have to use that on the exam. Not the right vibe. Now, here's the next thing for you. What if you want to hire a lawyer who's going to get you out of a criminal charge? Do you hire a first-year law school graduate or Clarence Darrow? Clarence Darrow? Perry Mason. If y'all are too young to remember Clarence. Y'all know Perry Mason, right? Who do you hire? First-year law student or Perry Mason? Why?
You got the right vibe.
But see, the Alabama State Bar says no representation is made that the quality of legal services to be provided are greater than the legal services provided by other lawyers. Rule 3.19, I think. It's at the bottom of all attorney advertising who've actually complied with the rule. That disclaimer has to be on all of it. So in your contract to hire Perry Mason, you can't say I'm hiring you because you're better than this other lawyer. The attorney can't put that in his contract. So y'all get it. It's personal services are personal for a reason, some of which you can put on paper and some that you can't. All right, 687, the top. In the middle of equal opportunity exception paragraph, it says the duty to mitigate damages is not applicable where the party whose duty is primarily to perform a contract has equal opportunity for performance and equal knowledge of consequences of non-performance. So what does that mean? In plain English, it depends, right? It depends on which person has the duty to mitigate, on whether or not they know about the damages and have the equal ability to avoid them. Now, foreseeability, 687. I think we're in the home stretch. Hadley v. Baxendale. if you didn't notice, is one of the biggie cases in contract. If you haven't put a big note and a star beside that case, go ahead and put a big star beside that one. It is huge. Or in presidential terms, it's hugely. Okay, Ms. McNeil.
I'm sorry, I stopped at the other one. I didn't go no further than the last one. I apologize.
All right, Ms. Leith. Where are you, Ms. Leith?
I'll do it.
Where's Ms. Leith? She answered roll. Oh. All right, Ms. Grabinski. Ms. Pleasure Johnson.
I'm good. I think it might have to win. Okay, so it's just me. Okay, so the plaintiff here was Hadley owned a corn mill. They had a crankshaft that went down, and without it, they couldn't continue to operate the mill, so they needed to get it fixed. So what they did was contracted with a shipping company owned by the defendant to ship it out for repairs. And they were told that if they got it to them by a certain time, which was noon, they would be able to deliver it to get repaired the next day, so they could get it back and open their mill back up. So they got it to them in time, but the shipper did not deliver it to the repair shop until several days later, which in that time, they were out of operations, and they sued for damages, including lost profits. The court ruled in favor of the plaintiff and defendant appealed. The issue I noted was the plaintiff entitled to lost profits for failure of the defendant to deliver the part needed to reopen the mill in the agreed time. Rule of law, when one party breaches a contract, the other party can recover damages that are reasonably foreseeable that both parties knew about when they made the contract, including anything that might be the special circumstances that were requested or relayed. The decision was reversed and remanded because it was found that the defendant could not have reasonably foreseen that the plaintiff would lose profits if they didn't get their parts to them.
All right, there was also a procedural reason for why it got reversed. On the top of 689, the court said it is indeed of last importance that we should do this, for if the jury are left without any definite rule to guide them, it will, in such cases as these, manifestly lead to the greatest injustice. Now, what did the judge just say happened there? He said we had a runaway jury that gave too much damages, didn't he? And the other part, the procedural part about why it got reversed is because the trial judge did not give a proper jury instruction to limit the damages. Now, getting that procedural part out of the way, another term you need to know is over on 688, null prosecci, N-O-L-L-E, prosecci. And you will notice that that term is sometimes abbreviated to null pros, N-O-L-P-R-O-S. So, nulli prosecci. Anybody want to take a guess what that Latin phrase means? Not prosecuted. Now, you'll see that most of the times in criminal cases where they're not going to prosecute you for a certain charge, they will null pros that charge, and then they sometimes will dismiss the charge. There's a difference between null pros and dismissal, I'll tell you that. You can ask your criminal law instructors what that difference is. But notice that null prosecci is the ability also of a plaintiff to say, I'm not going to prosecute this claim, even though they made the claim in their complaint. They get to pick what it is that they want to actually go forward with at trial. Down at the bottom of that page, in the paragraph that starts at the trial before Crompton, the clerk was told that a special entry, if required, should be made to hasten the delivery. It's 5 lines from the bottom. 688. 5 lines from the bottom of that second full paragraph. A special entry, if required, should be made to hasten its delivery. And that really told you all you needed to know for this case is that they didn't make that entry, did they? While the clerk said, if you have it here by noon, I can make sure it gets delivered tomorrow. They made sure it was delivered by noon, but there was a different clerk working that day. The first clerk did not make a special entry that says, be sure to get this there on time. Promised next day delivery. They didn't make that entry. Now, what would be the difference in the case if they had made the entry that says their plant has shut down and they need this part delivered next day in order to get their facility back up and running?
That would be a winner that loss.
Then it may have made it foreseeable, right? And if it was foreseeable, then you can recover for it. But the business itself, the delivery business, the only person that knew about it was the clerk who didn't make an entry, so the business itself had no knowledge of the fact that it was required, so they didn't know that lost profits would have been an issue.
I had a similar situation at my job. Sometimes I just ship stuff out for trade shows, and I indicated for FedEx to deliver it on next day, which would have been Saturday, check Saturday. But it didn't. I got a call saying that it wasn't there, so I called FedEx, and they told me that, oops, pretty much we'll get it there Monday. I told them, no, that's not going to work. So after about 5 levels up with me saying I want the next person, they had to go unload the truck. It was sitting in the city. They had to go unload the truck and get it off the truck and drive it to the site.
They actually did that?
Yeah. I'm pretty persuasive sometimes.
You're going into the right occupation.
Yeah, they did.
In case some of y'all didn't know it, sometimes they do same-day delivery on stuff. This was back in, in the 70s or 80s. I was working as a courier, and one of the things we had to do was package up something and take it to the bus stop so that the package got on a bus, drove down to another city, and it got unloaded in the city the same day. Well, that was back 70s or 80s. And now you see where you can take things to the airport, a package to the airport, and get it flown to a city and delivered same day. And now Amazon has got these flying things that can come drop it off on your front porch the same day. So you see how quickly we're moving toward instantaneous gratification rather than you order something and you wait for a month to be shipped. Yeah, nobody has any patience anymore. 689, look at the paragraph that starts off with, now we think the proper rule. I've got that whole paragraph highlighted as being good law. That if you hadn't highlighted that whole paragraph, make sure to go back and reread that part and put those in your notes. I'm not going to sit here and read it to you. And then on 690, it follows, therefore, that the lost profits here cannot be reasonably considered as a consequence of the breach of contract, as could they fairly and reasonably been contemplated by both parties when they made the contract. For such loss would either have flowed naturally from the breach, with great multitude of cases under ordinary circumstances, nor were under special circumstances where perhaps would have been made reasonable and natural consequence of such breach of contract, communicated or known to the defendants. Now you know why we went back and highlighted the fact that no special notes were made? Because this rule of law says if you communicate it and make it known to them, then they can be put on notice that this is a foreseeable damage, and you can recover that damage if it's breached. Everybody follow? Now, yes, ma'am.
So if you tell, let's say, carrier that it's important and they fail to put the note in, you know what happened, but if they fail to put the note in, and you're saying that it was foreseeable because I told you, who you sued doesn't have, you're saying they don't have notice of it, and you're saying that you did make notice of it. So,
Yeah, then it comes down to proof on, can you prove the business knew about it, or just the clerk who never made any notes?
so if the clerk knew about it, you didn't make any notes, but you didn't know that the clerk was making notes.
I don't know that you're going to be able to prove that they had notice.
Excuse me?
I don't know that you can prove that they had notice. The clerk did, but they didn't make any special note.
Because, I mean, I remember things happening, you talk on the telephone, you say a lot of things that, you know, to, let's say, a telephone, like AT&T or something like that, and they're supposed to be making these notes. You can't verify that they're making notes, obviously.
Unless they tell you they're recording all calls for quality assurance, and then you've got them.
Well, you ask for that now, but, okay.
Yeah, somebody's making a recording somewhere. Now that this case is done, and we've covered it, thank you, Ms. Johnson. There's another concept that you need to be aware of that's not very well explained here in the book, but it's going to apply to all of your other law cases in law school, and that is the difference between general damages and special damages. I'm going to give you a definition of general damages. General damages flow naturally from the action, and then special damages are those which are not general damages. In other words, they don't naturally flow from the action. You see where we're getting this from? It's that same paragraph I just read to you. General damages under contract law are those that naturally flow from the breach of contract, while general damages in torts are those types of damages that generally arise from a particular act. Give you an example. What if I have a negligence action and you're driving down the interstate and somebody rear ends your car? What kind of damages do you think you're going to have on that case? How about property damage? The back of your car, right? Does that naturally flow from somebody rear-ending your vehicle? Yes. What about medical bills? Like an x-ray to see whether or not you got whiplash. Does that naturally flow from? All right, what about a change in your heart medication? Does that naturally flow from a car wreck where you're rear-ended? No, it doesn't, right? So what the law requires, at least in civil procedure, when you claim that you have damages as a result of like a car wreck, a rear-end collision, you don't have to plead normal general damages with particularity. It's assumed that you're going to have the regular type of damages that anybody normally has if you're rear-ended. However, what if you were transporting your friend Bo Jackson's Heisman Trophy in the back of your car? And when you got rear-ended, it broke the Heisman Trophy right at the leg. You know that move, right? What if it broke the leg and he snapped over? Are you going to be able to recover for the broken Heisman Trophy? That's a special damage, right? So while you would ordinarily get general damages from the rear-end collision, it doesn't mean that the special damages didn't happen. It's just that you have to give the other side notice that those damages are there so that you can recover for them. It's the same general concept of law and contracts. If you're going to anticipate that you're going to have lost profits because your plant can't get to operating, then you need to tell the other side, time is of the essence. They don't use that term in here, but that's exactly the term that you need to know for contracts, is time is of the essence. I have people who are laid off from work and we're incurring expenses until we can get this part back and installed. And if you were to say that in your contract, would now these lost damages be recoverable if they breached? Because it's foreseeable, right? Yes, ma'am.
What if, like, because in this case, it sounds like he was told to drop it off this time and be done the next day. So because that section and then he was the need to, because he relied on what she told him, he did not feel the need to go further into explanation. So that's one thing that I'm kind of, I don't think it's really fair because everybody necessarily, I don't understand the importance of why everybody has to go into their urgent situation if they already were told this will be done in time. You know what I mean?
I do. Let me tell you why the difference there, though. Y'all are in law school. Now you know there's a difference. You got to spell it out for them, or otherwise you're not going to be able to recover. So if you have a client that comes to you and says, look, I'm running this facility, say you're the in-house counsel for the cornmeal plant, and you have a broken part, and as the attorney for them, you say, well, when you take it for delivery, make sure you know that we are incurring expenses every single day that's not here, and that time is of the essence to get that part back and installed so that we don't incur these additional losses daily. Now, if you were to, as attorney for that company, to draw that up and put it in the contract, could you now recover those damages from the shipper if they don't get that part delivered timely? That's why people get lawyers, because you study this stuff and you know the key things that need to be put in contracts in order that you can be made whole in the case that somebody breaches it. Look at 691. The House of Lords recently overturned Hadley v. Baxendale. That's just over in England, though. It's still the good law over here. Restatement sections 351 and UCC's 2-715. And then note number 2, the rule in Hadley is an attempt to restrict liability for a promise or a breach of a promise to those consequences, the risk which he knew about or must have been taken to have known about when he made the contract. That's actually a pretty good statement of what the rule in Hadley v. Baxendale is. British Columbia Sawmill Company versus Nettleship. Now this is a funny case. This guy's going to be married to an heiress. He's going to be a kept man. If you read in between the lines, he's going to be a kept man. He starts riding out on a horse to get to the wedding. The horse throws a shoe. The blacksmith doesn't fix it. The horse becomes lame. He doesn't make it to the wedding, and she marries somebody else. And now he's suing the blacksmith because he allowed the horse to go lame. Is it foreseeable that he won't live as a kept man if the horse doesn't get the proper fitting on a horseshoe? The key to that case is at the very bottom of the paragraph says damages are too remote. If it's not foreseeable, then they say the damages are remote. That's your key legal term for this. If it's not foreseeable, it's remote. If it is foreseeable, it's recoverable. And then restatement 351. And 351 puts a limit on it that says even if it's foreseeable, they don't want disproportionate compensation. So there's a further limit on it. top of 692, a small fee charge could not have been intended to cover the risk of a liability. The ship classification industry could not continue to exist under such terms. That was a cruise ship that wasn't built properly. Now, visit consequential damages again. And they say special damages are consequential damages. Then you've got a whole bunch of UCC sections. All right, next case, Ms. Carol Johnson. Delchi Carrier Spa versus Rotorex. $692. Carol Johnson.
I'm here. So this one, the plaintiff ordered compressors from the defendant to be used in air conditioners, and they received a sample, and like the sample and specifications that were provided, but when the first shipment arrived, it wasn't the same quality. So they refused the other sample to cancel the contract, and then they filed suit under the thing called Contract for International Solar Goods. And they held that yes, because the sample was different from what was actually received, that they ruled in favor of the plaintiff, and they so the defendant was liable for the breach.
And not only the breach, but storage expenses, the shipment, the tooling expenses, the cost of useless insulation and tubing materials, and consequential damages. They just went on an entire laundry list of all the different damages that they could recover as a result of that breach. If a look on note 2, a buyer for resale. If a seller knows that is selling to a buyer for resale, loss of profits is generally regarded as foreseeable. But if you were selling something to somebody who was going to use it, do you anticipate that they're going to have lost profits from it? No, you don't, do you? If it's for their personal use, even if it's a business, if it's for their business use, if they're going to use it, you don't anticipate that they're going to sell it and have profits. So lost profits would not be something foreseeable. Look at this next paragraph. The garments had serious defects, quote, too risky to market. When I read that, I thought of LaToya Jackson. The garments were too risky. Oh, come on, folks. Y'all don't watch Super Bowl?
Yeah, Super Bowl show. Yeah.
Janet Jackson. My bad. Janet Jackson. She was the one with the wardrobe malfunction, right?
Yeah.
Sorry, my bad. I knew it was one of the Jacksons. Down at the bottom of that, they're talking about Daewoo. A rational jury could conclude in circumstances that Daewoo could have foreseen that a non-conforming tender, risky garment defects, as severe and pervasive as the present evidence demonstrates, probably would cause them in the ordinary course of business to lose future contracts with Champion. Now, y'all know where Russell Athletics is, right? Sylacauga. Now, what if Russell had a contract to build the uniforms for the cheerleaders for the Atlanta Falcons? Y'all with me? And what if the uniforms that they built had wardrobe malfunctions like Janet Jackson? Do you think Russell would ever get another contract from the Atlanta Falcons? Or from any other team? That's what they're talking about, is it damages the reputation as well. And it's foreseeable that if with the damaged reputations, they could lose future contracts. All right, Ms. Erlana Johnson.
In
Kenford.
I'm here.
Kenford.
In Kenford County Kenford versus County of Erie. Kenford County entered into a contract with the County of Erie to donate 178 acres of land. It was for a stadium near Buffalo, and the plaintiff agreed to do this in exchange for the management company of DSI to manage the facility. And the plaintiff, Kenford, also owned the land in the periphery or around the area of the stadium site. The construction was supposed to start in 12 months and negotiate a 40-year lease. And the defendant would also receive increased property taxes and revenues generated by the plaintiff, but they decided not to build the stadium, and the plaintiff sued for the loss of anticipated appreciation of the value in the land. The trial court awarded damages, and the county appealed, and at the appellate level, the judgment was reversed, and the loss of anticipated profits was stricken.
You want to take a guess who they were building the field for?
The Buffalo Bills.
Probably so. Go ahead.
The issue here is the plaintiff entitled to recover damages from anticipated loss of what the appreciation would be. I had to look up the law again, but a non-breaching party is only entitled to damages within the contemplation of the parties at the time of contracting. So, are they responsible or entitled to recover? No. But I was a little bit confused about the whole thing and just
Okay, let's talk through what the facts
wanted
are.
an example.
They want to buy land to build a dome stadium. Kind of like what Birmingham wants, right? They want to build a dome stadium. They've got a place picked out for it, land picked out for it. It's over there on the north side.
Who's going to pay it?
We ain't gotten that far yet. Neither has the city council, I don't think.
Just kidding.
All right, but there's a parallel here. They want to build a dome stadium, and they want to build a dome stadium here. They've got a parcel picked out in Buffalo. They've got a parcel picked out here for the dome stadium in Birmingham. Well, now let's say the location that they have picked out here in Birmingham, you find out what that location is, and you decide, hey, I can make some money. So you start buying up property around where the property is for the dome stadium. Everybody follow me so far? Yeah. Well, this same business who actually owned the property for the stadium decided it wanted to also buy property surrounding the stadium in anticipation that the stadium is going to be built, and they can now start renting out places, commercial ventures for restaurants, hotels, and everything else. And they're looking at making a lot of money. You have that same idea that you want to buy property downtown Birmingham, right across from where the stadium's going to be built, and you want to build some property so that you can rent it out and make lots of money. Is everybody following so far? Yeah. What happens when the dome stadium deal goes through, but you've already bought that property? You still own it. How much is it worth? Probably about the same as what you paid for it, right? Are you entitled to the lost profits of what you expect the value of the property to be if they actually completed the dome? That's what this case is about. Except that instead of you finding out that somebody else is going to build a dome stadium on their property, this was the same person that owned both the property where the dome was going and bought up the property around. Now, if it were a stock market, they'd call that insider trading, right? But they found out about where the location was going to be and started buying up property. They were taking a risk. It's called entrepreneurial risk. And if it doesn't materialize, then you're just out the money. The good thing is you're not out the money until you actually sell the property, just like the stock market. You don't lose money when the stock goes down. You simply wait and hope it goes back up. Unless they go out of business, and then you lose money. That's just the nature of the free market. So you buy the property, hoping that the value will go up, but if it doesn't, do you have a lawsuit against the company that was trying to build the Dome Stadium for the lost value of what you think your property would have been worth had they actually built the Dome Stadium, and thereby improved the value of all the properties surrounding it? And that's what this case is. No, you don't have an action for what you think the property should be worth. You took the risk just like anybody else would have taken the risk. And that's its expectation of financial gain would be unrealized. That's it. It never came to fruition. Let me give you another example about how people do that. Y'all have heard about the Northern Bypass? 459, they're going to finish the northern loop around Birmingham, so it looks an awful lot like Atlanta. We're going to have an interstate that runs all the way around Birmingham. Well, when they were talking about finishing up that Northern Bypass, what do you think people did with the land that was up there? They were buying it up, hoping that that would be the property that the government condemned, which would now be more valuable because there's going to be an interstate there. And if they're really smart, they got the property just off of there, which they could create an exit and sell out commercial real estate, sell it or lease it out, and make lots of money. That's another example about how these ventures just don't work sometimes. Mere notice to a seller of some interest or probable action to the buyer is not enough. That's note number 1 on 698. On limitation of risk. Was it actually made known to the builders of the Dome Stadium that they were anticipating improvements in the property value surrounding it, and that if they breached the contract that they would have a loss for the commercial value improvement? They didn't put that in their contract either, did they? Why don't you think they put it in their contract? All right, let's do it as a hypothetical. What if you find out that they're going to build a Dome Stadium and you know the exact location of it? Might you want to buy some property that's located right around it?
Yeah.
Would you want to tell somebody you're buying property right around it so that when the Dome Stadium, they'll beat you to it, won't they? That's part of that competition. You don't disclose your cards because you don't want to give away your profit. But when you don't disclose it, you can't recover for it because it's not foreseeable. You didn't put it in your contract. Had they put that in the contract for the Dome Stadium, what do you think the city would have done? They'd have bought up that property too. And therefore it was all non-recoverable. The last thing we're covering for today is on 700. We're stopping on 701, right before emotional distress. The important thing about sentimental value is the last of that first paragraph. The rule has been established that compensation for sentimental or fanciful values will not be allowed. Now, let's take an extreme example of this. You have got an urn at home, an urn, URN, with the ashes of your favorite grandmother. All right, who's your favorite grandmother? The one who always baked you everything you wanted when you went to visit. And so you've got this real strong attachment to the ashes left behind by your grandmother. And you contract with somebody to transport it because you're going to move. You want it transported from where you live now to where you're going to live. And it turns out the transport vehicle was involved in a wreck, which caused the urn to open up and the ashes to blow away. Open up, it cracked the urn, so the urn's no longer any good. What kind of cause of action do you have against them for the transport and the breaking of the urn? There is no price to it, is there? Is it sentimental? You betcha it's sentimental. My favorite grandmother? Now, what's the damages? You can't be compensated for that, right?
Not allowed. You can't.
In those instances, it says that there are no legal damages. Now, are there damages for the broken urn? Yeah, we'll go buy you a new urn.
Wow.
Well, what's that worth? You want your grandma too, right? So what's it worth? There's not a price tag you can put on it. So that's why they say fanciful and sentimental values are not recoverable. And when you get a client that comes in and says, I want to sue them for what they did to my grandma's ashes, make sure that you get paid hourly and in advance. Because they're not going to recover anything.
They can't recover under like negligence if they didn't secure the.
Okay, but what are your damages?
I mean, the urn.
The urn. You get what? $150 back for a new urn. Yes, ma'am.
Could they recover for the price of getting your grandmother cremated? Because technically you don't have the action anymore that you paid that service.
What in your contract?
Let's put it this way. If your contract for transporting your grandma, you said, by the way, if you ever get involved in a wreck and you lose my grandma's ashes, I will have suffered damages for the cost of having her cremated that I will need to have compensated, then it might be foreseeable.
They'll think you're crazy.
That's foreseeable.
Emotional distress?
I'm so upset over this. I can't go to work. I had to start seeing a psychologist. I mean, could you not go down that road?
But they didn't have intent.
You don't have to.
Emotional distress.
What damages do you have other than fanciful or sentimental?
Well, if I can't go to work because I'm too upset or I'm sick or something as a result of emotional distress.
You probably should have made it yourself.
You can try it.
Grandma's ashes probably should have been in your car.
All right, before we leave for the day, because we've covered everything we need to, anybody that came in after I called roll, please come see me. And then I'll see you guys next week. And I think next week, if I remember right, is the last of the new material that we covered before the midterm. On 2.2 we cover up to page 749. On 2.9 is the review, and on 2.16 is your midterm. So next week is your last of your new material.